case briefs, and so much more. LSData's got what you're looking for.
In 2011, the Colorado Supreme Court presided over the case of Lucht's Concrete Pumping Inc. v. Horner, which centered on the idea that as long as an employer is not acting in bad faith, the employer's forbearance from terminating an at-will employee constitutes adequate consideration for a non-competition agreement. The case arose from an employment dispute between Tracy Horner, a former employee of Lucht's Concrete Pumping, and Everest Materials, LLC, Lucht's competitor who later employed Horner. Lucht's, a Denver-based concrete pumping company with approximately 70 employees, argued that forbearance from termination was enough consideration for the non-competition agreement Horner signed. The initial court ruling disagreed, but the Colorado Supreme Court later reversed the decision, stating that forbearance from termination was, in fact, adequate consideration. The court emphasized any benefit to the employer or detriment to the employee, however small, counts as consideration, and that non-competition agreements must be reasonable. Ultimately, the Supreme Court sent the case back for further proceedings to determine if the non-competition agreement was reasonable. The court clarified that employers couldn't evade reasonableness evaluation by terminating and rehiring employees with non-compete agreements. Furthermore, agreements could fail due to lack of consideration if an employer intended to terminate the employee immediately after signing.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.